What about copyright? As we see in our notes here, you can have direct, indirect, criminal, civil infringement for copyright. The issue with copyright, as we saw with the Men at Work copyright case, the infringement case there with poor old Mr. Greg Ham, the court has to work out whether you have in actual fact taken a substantial part of the copyright work or other subject matter. If you have and you've had no authorization from the copyright holder, then unfortunately you will be squarely in the crosshairs of an infringement action. So pretty much in a similar vein to patent infringement, you're going to need to show the essential material features have been taken. If these essential features, like that riff in the Men at Work song, the Down Under song, have been taken, then it's more than likely you will have taken a substantial part. Direct infringement is the doing of any of the copyright owner's exclusive rights as set out in Section 31. And I don't think I've put that provision in this Ready Reckoner because it's fairly lengthy. So here we are at Section 31 in the legislation, and you can see these are all your exclusive rights you have as a copyright owner. So reproduction in a material form, publication, performance, communication to the public to make an adaptation of the work, and also if it's an artistic work, you have the right to reproduce in material form, to publish it and to communicate the work to the public. In the case of a literary work other than a computer program or musical dramatic work, you've got the rental arrangements there. In the case of a computer program, to enter into a commercial rental arrangement in respect of that program. So there are your exclusive rights for copyright works. Then if we flip over to Part 4, Division 2, we see nature of copyright in subject matter other than works. So here pretty much what you would expect: nature of copyright in sound recordings. You have the right to make a copy, cause it to be heard in public, communicate it to the public, and the rental arrangement there. For films, right to make a copy, cause it to be seen in public or heard in public, and to communicate the film to the public. And broadcasts, similar things there. For TV broadcasts, for the visual images, to make a film of that, or for sound broadcasts, to make a sound recording of the broadcast, or in the nature, if it's a TV or sound broadcast, to rebroadcast or communicate that Part 4 subject matter to the public. Okay. Published editions, well, they're kind of the, added afterthought. But copyright in relation to a published edition is the exclusive right to make a facsimile of the edition. That is the exclusive right to copy it. Okay. So there we have all of the exclusive rights in the copyright house, if you will. And infringement, obviously, direct infringement, as I was saying before, was doing of any of those exclusive rights, not just in Section 31, but if it's Part 4 subject matter, then any of those rights that we've looked at there. Indirect infringement is where you import a copyright article without authorization. Infringement can also be by authorizing somebody else to do something that's within one of the copyright owner's exclusive rights.
You can do it! You can do it! You can do it.
And The main exceptions, I'll just flick up here for you. The main exceptions: free copying by libraries, that's a fairly, sensible one. Fair dealing, and I haven't bothered enumerating all of the provisions in here for you, but we have the usual suspects. So research or study, criticism or review, parody or satire, reporting the news, and there are a ragtag bunch in sections 43 and 44 of other fair dealing exceptions. Section 115 is the ability of the copyright owner to bring an action for infringement. You will note that the relief in 115 sub 2 is an injunction, damages, account of profits, again, similarly to the patent legislation. So I've popped up here for you. They are the remedies that you can get. Interestingly, with copyright, you do stand the chance to get additional damages if the conduct by the defendant has been quite flagrant. Okay. Again, unjustified threats are not on and they are unlawful. So what you can't do, similarly to the patent legislation, is make big, nasty, mean threats and just never actually file proceedings in court to back up your threats that you maintain that the other person is infringing. Okay, and that's pretty much it for copyright. Okay, so for trademark infringement, we don't really need to belabor the point because we've already gone over section 120 in a reasonable amount of detail, partly in the trademarks week and probably more so in the passing off week. But we've principally, to this point, looked at section 120 sub 1, where a sign is used as a trademark that is substantially identical with or deceptively similar to the trademark in relation to exactly those goods or services in respect of which the registered trademark has been entered on the register. Subsection 2 deals with the situation where goods might be perhaps not exactly as is entered on the register, but they are of the same kind of description as those goods or closely related services that are closely related to those goods, or services of the same kind of description or goods that are closely related. So that deals with a bit of a broader idea where the goods are pretty much like what has been claimed in the trademark register, the classes of goods or services, but they're the same description, okay? Obviously, as I've highlighted there in yellow, there's not going to be any infringement if there's no confusion, and that really gets down to, the policy rationale for trademarks. The whole point of trademarks in terms of regulatory policy is to preserve those marks as a reasonably accurate indicator of source, okay, so that the consumer can go back and repurchase their goods or services that they like. If there's no deception, no confusion, well, then there's not going to be much of an argument there to enforce the mark against anybody. Subsection 3 deals with the situation where a mark has been used on different goods or services, completely different goods or services than the mark has been registered for, and in the ordinary course of things would not constitute an infringement. In subsection 3, what tips it over into infringement is the introduction of that element of confusion or deception, and that turns upon how well known the trademark is, okay? So if the mark is well known in Australia and then somebody rips it off, uses it in relation to, as you can see there, 3B1, goods unrelated goods that are not of the same description, or subpara 2 services, unrelated services that are not of the same description. So there was a case, not in Australia, but it serves to underline the point. There was a little doggy toy manufacturer. I'm not sure what jurisdiction this was in. I read it on the Fashion Law blog just recently. A little doggy toy manufacturer that made toys that were shaped like ladies' handbags, and these chewy toys for your dog were called Chewy Vuitton, and they were brown and they carried the Louis Vuitton, hallmark markings, their trademark markings, and your little dog could chew away at this little faux leather handbag. The dog goes woof. Louis Vuitton obviously objected to this, and the question there was, was this kind of item likely to cause confusion or deception? And the court held no, because not only were the words Chewy Vuitton fairly prominent at the top of the little chew toys, Vuitton was spelled differently to Louis Vuitton. It only had one T, and it was said along the lines of parody. Whilst there might have been a calling to mind of Louis Vuitton's mark, there was certainly no one was under any illusions that these little things were made by Louis Vuitton. They were cheap, they were disposable, and they were for your dog to chew on. So that's the kind of thing that the big boys like Louis Vuitton would tend to use. That's the provision they would go for when there are goods on the market that are unlike their own goods, but they still want to prevent them being sold on the market. In terms of defences, 122 is the main provision that you want to have a little look at. And if you're going about your trading and you're using someone's mark in the course of trade to indicate your name or your place of business, the kind, quantity, quality, intended purpose, all of those characteristics of your products, all of this kind of good faith use, it's not going to be trademark infringement. And this provision harks back to our discussions previously about not fencing off parts of the language that other traders will legitimately need to use. And we talked about this when we spoke about the difference between descriptive marks, so apple for apples, or distinctive mark, so distinctive marks being Apple for computers. So that requirement for distinctiveness is very bound up with the whole notion of not fencing off the language where other traders would need to use those common terms. So if you do need to use it for indicating the characteristics of your goods, then you're likely not going to be infringing. In terms of what you get if you are successful in an infringement action, pretty much the same as we've seen previously. So you can get an injunction and damages or an account of profits. And if we look up here, I have put them in the remedies column as well. Now, one little thing that I will mention before I leave off with trademarks, and that is the whole issue of exhaustion.
And I'm like, oh my gosh, I am so tired.
Exhaustion is an interesting little principle. I haven't put it into our Ready Reckoner, but I will take you to the legislation. And here we see the provision that deals with exhaustion. In spite of Section 120, a person who uses a registered mark in relation to goods that are similar to goods in respect of which the mark's registered doesn't infringe that mark if the mark's been applied to or in relation to the goods by or with the consent of the registered owner. Okay, similarly, a person who uses a mark in relation to services will not infringe if the mark was applied in relation to the services by the owner. Now here we have a provision that very squarely deals with the issue of the purchaser of a product that has a mark applied to it being able to deal with that product after they have purchased it from the legitimate trademark owner. Okay, so you've gone ahead, you have bought your Louis Vuitton bag, you have used it for some time, and then you wish to sell it. What is to stop you putting that on eBay? And the answer is nothing, because once that mark has been applied to those goods by the trademark owner and sold in the course of trade, that purchaser then can resell the product without fear of infringement. Okay, the trademark right is not intended to stop that secondary market in used goods. Okay, now there is a bit of a question here about international exhaustion, and for example, where an Australian mark owner has goods manufactured elsewhere, perhaps because it's cheaper. If the goods are manufactured, for example, in China, the mark is applied, the Australian registered mark is applied in China. What about someone that sources some of those goods from the Chinese manufacturer? Can they then bring those goods into Australia to compete perhaps at a cheaper level with the Australian trademarked goods? And the short answer to that is no, they can't, because of Section 123. There have been some instances where companies have sought to get around Section 123. For example, structuring the ownership to avoid the trademark owner actually giving consent to application of the mark produced elsewhere. And you'll see here in this nice little article, actually I'll post up a link to this article, but you had an overseas company's Australian trademark registration being assigned to the local entity. The parent company didn't wish to risk losing ownership or control of its marks, so it prepared an agreement dealing with the assignment back of the marks, and the assignment being triggered on certain events, for example, insolvency and so forth. So you've got all these complicated structured deals trying to get around Section 123. In most cases, I think you'll find that the court will see through the attempt to get around Section 123, and they will unfortunately not cooperate with these kinds of complicated agreements. Interestingly, there's no real, there's no direct provision in the Patents Act, as there is in the Trademarks Act, dealing with exhaustion of patent rights. However, you'll see if you have a little look at this article, there is a fairly well recognised consensus that patent rights are exhausted upon the first sale here locally in any event. However, given some UK jurisprudence, it may be somewhat easier for a patentee to prevent the parallel importation, like the importation of cheaper patented goods from overseas being brought over here to compete with the local product. It may be easier for them to prevent that happening through the patent right. However, there's really no local case law, so the position is a little bit more up for grabs than it is in the UK. In any event, if exhaustion is something that interests you, go and have a little look at this article. And that brings me to a very brief recap of the actual remedies that you can get and here we have injunctions. You will recall from other units in your degree studies that in order to get an injunction, you need to make out a prima facie case. There has to be a sufficient likelihood of success. There needs to be a serious question. And there you need to show the court that the plaintiff's probably going to suffer some kind of injury for which damages won't really compensate. And that the balance of convenience lies in granting the injunction rather than letting compensation take its place. And you also need to show that the need for protection really outweighs the consequences. So the court will have a little look at, well, what's going to happen if we grant this injunction? Is it going to produce some kind of really dire circumstance for the defendant? And, you know, what really washes out as, you know, do we really need to give that protection, or are the consequences going to be too dire? Damages, we all know what damages are. I've got the sections in the Act there that allow damages. We know that they're compensatory, so they're not punitive in most cases. However, under the Copyright Act, as I said, you know, you can seek additional damages if the conduct has been quite flagrant. You also find these in the Patents Act as well, and the Trademarks Act there. For breach of confidence, you're going to be seeking equitable damages. An account of profits is an alternative to damages, and we know that they are an inquiry into exactly how much money the defendant has made from their wrongful conduct, and then it is simply a matter of the court taking that quantum of profit and awarding it to the plaintiff. Declarations and orders. There are a number of declarations and orders that the text goes through. I'll leave you to have a look at those. Criminal liability as well. There is criminal liability under each of those pieces of legislation. And lastly, I just wanted to remind you about all of the different remedies that you can get under the Australian consumer law. So we have there actions for damages, yes, obviously, but we also have these rather beautiful and non-punitive orders. There's a whole range of orders that the court can make there. Anything from directing somebody to do something right through to things like compliance programs and orders to publish advertisements. So have a little look at those provisions of the Australian consumer law, and that's pretty much it for infringement and remedies. Like I always say, if you have any queries, have a chat to me in the forums in Moodle, or email me, tweet me. Other than that, if you like this video, give it a big thumbs up and subscribe. And I'll talk to you soon, hopefully in a Zoom or a forum. Thanks, guys. Bye.